2018, where the claimant as CW1 testified on 28th of March 2019 and tendered exhibits CW2 to CW25. Similarly, exhibits CW26 to CW27A to G were also tendered through CW1 under cross-examination. Claimant was cross-examined and discharged that there was no re-examination. On the 3rd day of July 2019, defendant's witness, Fumilayo Oye 2C, testified as DW1 and tendered as exhibit DW1A to D and DW2. She was then cross-examined and decided that there was no re-examination. On 24th of May 2017, leave was granted the claimant to amend his statement of fact, or the defendant's statement of defense was amended by an order of court on 13th February 2019. The defendant also filed a counterclaim against the claimant. The claimant further filed a reply to the amended statement of defense and the counterclaim on the 20th day of February 2019. But the amended statement of fact dated on the 7th February 2017, but filed on the 1st of March 2017, the claimant seeks the following reliefs. Number A, a declaration that by the action AS Nigeria's policy manual 2010, enhancing Nigeria's response to HIV and SENR programs, standard operating procedure, SOP in bracket, declaration of conflict of interest by the claimant to Johnson Ekele, his line manager, was sufficient to qualify as such, and it was not mandatory for him to put it in writing to the respondent. Number B, a declaration that by the tenor of the email appointing the Gimba-led panel, on the corner of the panel refusing to call Johnson Ekele to testify in favor of the claimant, the claimant was denied fair hearing and presumed guilty by the respondent, and the Gimba-led panel set up by the respondent to investigate allegations of dishonesty against him and made to prove his innocence contrary to the provisions of Chapter 4 of the Constitution of the Federal Republic of Nigeria 1999 as amended. Number C, a declaration that having found after the review of the findings of the Gimba-led panel that the claimant had declared his conflict of interest to Johnson Ekele, the state program manager of ENR, who was his line manager, and whom by paragraph 2 and 3.7 of the ENR standard operating procedure, he was bound to report such conflict. The respondent was not justified in still finding the claimant guilty of dishonesty and fraud for not reporting conflicting interest and reverting his termination of appointment to 4 months suspension without pay. Number D, a declaration that the termination of the appointment of the claimant by a respondent on grounds of dishonesty and fraud was wrongful, illegal, unconstitutional, null and void, and of no effect whatsoever. There was no basis in law and in fact to revert same to 4 months suspension without pay on compassionate ground other than exonerating the claimant of any wrongdoing. Number E, a declaration that the claimant is entitled to a reversion of the suspension on compassionate grounds to a finding that he declared his interest in Emma Foundation, and the declaration was officially acted upon by his line officer, and there was no evidence that he interfered with or was involved in the day-to-day running of Emma Foundation. Number F, declaration that consequent upon the above, the claimant is entitled to be reinstated and restored to his full rights and entitlements for the period of the illegal suspension from June to September 2011, and the said 4 months be reckoned with in the final calculation of his terminal benefits at the end of his contract with the respondent as at 18th January 2012. Number Z, a declaration that the claimant is entitled to an apology from the respondent for wrongfully smearing his name and tagging him with a stigma of dishonesty and fraud, as well as paying him damages. Number 8, an order of the Honorable Court directing the respondent to reverse the suspension of the claimant on compassionate grounds to a finding that he declared his interest in Emma Foundation and the declaration was officially acted upon by his line officer, and there was no evidence that he interfered with or was involved in the day-to-day running of Emma Foundation. Number I, an order of Honorable Court directing the respondent to reinstate or restore the claimant to his full rights and entitlements for the period of illegal suspension from June to September 2011, and the said 4 months be reckoned with in the final calculation of his terminal benefits at the end of his contract with the respondent as at 18th January 2012, as if he was not suspended at all. Number J, an order of Honorable Court directing the respondent to pay the claimant in full his entitlements for the period of June to September 2011, representing the period that he was wrongfully suspended and denied to his entitlement. Number K, an order of the Honorable Court directing the respondent to immediately calculate and pay the claimant his terminal benefits based on the above recording, including the 4 months wrongfully denied him by the purported suspension. Number I, an order of Honorable Court directing the respondent to tender a written apology to the claimant for wrongful termination of appointment on grounds of dishonesty and fraud, and subsequent wrongful conversion of suspension on compassionate ground and resultant stigma attached thereto. Number M, 200,000 naira damage for violation of the claimant's right to fair hearing, wrongful termination of appointment, and conversion of wrongful termination to suspension without pay for 4 months. The defendant in his contract claim, on the other hand, seeks the following reliefs against the claimant. Number A, that the claimant / defendant to contract claims should be dismissed with substantial cost. Number B, an order of this Honorable Court directing the claimant / respondent to the contract claim to return the sum of 1,097,264 naira 25 kobo paid into the account of Emmanuel Marco Ade Foundation, Development Foundation for the execution of project. Number C, damages against the claimant / defendant to contract claim for the inconveniences caused to the respondent / counter claimant. Case of the claimant. From the fact averred by the claimant, he was employed by the defendant in 2005 on a 3-year contract job at the Capacity Building Technical Advisor on the project Enhancing Nigeria's Revenue, ENR, a program carried out by the defendant in conjunction with Benue State Action Committee on AIDS. In 2009, the claimant's 3-year contract was renewed for another 3 years, but by virtue of the defendant's 2010 policy, the claimant was required to declare his complete interest in any project or program undertaken by the defendant. But according to the claimant, the policy did not state the method of the declaration of conflict of interest, whether it must be a writing or verbal. The claimant was then seconded to a project called Enhancing Nigeria Revenue, ENR, HIV/AIDS in Benue State. Claimant avers that the ENR had its own standard operating procedure, SOP, and that he was no longer bound by the policy manual of his employer, the defendant. Claimant further stated that one of the NGOs involved in the ENR was Emma Foundation, based in Wandekea local government in Zone A Senatorial District of Benue State. The claimant was a board member of Emma Foundation, which was also a beneficiary of funds under ENR, and in accordance with the policy of declaration on conflict of interest of the defendant and the standard operating procedure of the ENR, claimant stated that he declared his involvement in Emma Foundation by orally informing his line manager, Johnson Ekeli, the state program manager of ENR. According to the claimant, as a result of his declaration, Johnson Ekeli posted him to the Senatorial District of Benue State to work there so as not to be involved in the selection process of benefiting NGOs in Zone A, where Emma Foundation was located. Claimant further avowed that he was not a signatory to any of the accounts of Emma Foundation, nor was he involved in the day-to-day running of the Emma Foundation project. The Emma Foundation had internal issues that were making it impossible to deliver on their mandate, and the claimant advised them to return the money received for the program, which they did and later withdraw from the program. But when Emma Foundation withdrew from the program, the defendant set up a panel headed by Gimba to investigate circumstances surrounding the withdrawal of Emma Foundation from the program. The panel recommended termination of the claimant's appointment, and he was so terminated by the defendant on grounds of dishonesty and fraud. Dissatisfied with the decision of the panel, the claimant appealed the decision of the Gimba-led panel to the defendant, who set up a review panel, and based on the review panel's report, the defendant converted the claimant's termination of appointment to 4 months suspension without pay on compassionate ground. However, in August 2011, the claimant's appeal to the board of the defendant against the conversion of his termination of appointment suspension for 4 months without pay was rejected. Case of the defendant on his part, while denying the claims of the claimant, stated that it complied with his policy manual in terminating the claimant and converting the termination to suspension. The defendant denied violating the right of the claimant as alleged, and contended that the claimant was properly investigated by a panel, and he had all the rights to appeal, and indeed did appeal the decision of the panel. According to the defendant, its findings revealed that the claimant violated his policy on declaration of interest and pursuing outside interest. That though the claimant was seconded to a project called Enhancing Nigeria's Response ENR to HIV/AIDS in Benue State, he still remained a staff of the defendant and was bound to obey its policy manual. At the close of the case of the parties, the matter was adjourned for addition of final written addresses. Defendant's written address. The defendant's final written address dated 7 November 2019 was filed on the 8th November 2019, wherein Land Council on behalf of the defendant formulated 2 issues for termination to it. Number 1, whether the claimant has successfully proved his claim before this court on the preponderance of evidence to be entitled to the relief sought. Number 2, whether the defendant's counter claimant has successfully proved his counter claim against the claimant. Issue number 1, Land Council for the defendant on the first issue submitted that the burden of proof lies on the party who would fail if no evidence is laid by both parties in the suit. It's also submitted that it is he who affirmed the existence or presence of fact that ought to show its existence through credible evidence, and not the party who denied the existence of such fact. Counsel cited the case of Maidara and Halilu. It was submitted on behalf of the defendant that claimant's duty in proving his case is to show that the defendant failed to comply with the contract entered into with it while taking disciplinary action against him, or that the defendant had no power to act in the manner it acted with respect to the disciplinary action taken against him. Counsel contended that the claimant contravened his employment contract and the defendant's policy manual by not declaring his interest. The defendant further contended that the alleged declaration of interest by the claimant to Johnson Ekele shows that the claimant was aware of the issue of declaration of interest as part of his contract of employment. Claimant's employment letter XB2 and defendant's policy manual XB3 were referred to by the defendant. It was submitted by the defendant that a collective reading of his policy manual will show that a staff of the defendant is prohibited from pursuing outside interests, especially where such outside interest will conflict with his employment with the defendant. Counsel on behalf of the defendant also referred to Section 128 of the Evidence Act to submit that the claimant cannot by oral evidence contradict Corporate Affairs Commission documents exhibits CW26 and CW27A to G, which show that he is the chairman board of trustees of Emma Foundation. It was argued by the defendant that the claimant had been acting as the chairman of Emma Foundation since 2003, and registered in 2006 without disclosing this to his employer, and that the fact that the defendant only came to be oblivious of the information in 2011 does not prejudice his right to discipline the claimant. It was maintained by the defendant that the claimant's right to fair hearing was not violated, that if the country director of the defendant had prejudged the guilt of the claimant, he would not have set up an independent body to carry out an investigation into the allegation. The dismissal of the claimant was not based on the country director's opinion about the allegation against the claimant, but based on the recommendation of the panel that duly investigated the allegation against the claimant. Counsel cited the case of Umar and Effion. On issue 2, Learned Counsel submitted on this issue that the claimant has caused pain and suffering and inconveniences to the counter-claimant. The counter-claimant, whose head office is located in Abuja, Nigeria, expended a lot of resources in defending this suit since 2014. Hence, its claim for general damage for the inconvenience, pain, and suffering caused by the claimant in defending this suit. Claimant's final written address. The claimant's final written address dated the 13th of January 2020 was filed on the 17th of January 2020, wherein Learned Counsel to the claimant submitted the following issues for determination. Number 1, whether the claimant declared his conflict of interest as required by the respondent's 2010 policy document. Number 2, whether the claimant was given fair hearing before his appointment with the respondent was terminated and subsequently converted to suspension. Number 3, whether the respondent has proved his counterclaim against the claimant. Issue number 1, counsel on behalf of the claimant contends that the claimant declared his conflict of interest as required by the defendant's policy manual, exhibit CW3. That by the said exhibit, defendant staff were required to declare their potential or real conflict of interest with the defendant. However, exhibit CW3 did not state the method of the declaration of interest, whether it must be a writing or verbal. Counsel referred to paragraph 4.11.2 of exhibit CW3. It was further contended that there is nothing that suggests that the disclosure of conflict of interest must be a right. Counsel referred to the case of FO of Bagbe and FBN to submit that where no specific provision is made for the doing of a thing, any legal procedure which is adopted is acceptable. Claimant stated that he had interest in Emma Foundation, which was formed by his family in memory of his late father, and he declared his conflict of interest in Emma Foundation to his line manager, Johnson Ekele, who was, as a result of that declaration, deployed the claimant to a different senatorial district of Benin State in order not to get involved in the selection process of benefiting NGOs where Emma Foundation was located. Counsel argued that the Gimba-led panel set up to investigate the claimant did not call Mr. Johnson Ekele to confirm his claim, but went ahead to find him guilty of dishonesty and recommended his termination. Claimant submitted that when the review panel found the claimant declared his interest to Johnson Ekele, it converted his termination to suspension instead of exonerating him completely of the allegations. Claimant further submitted that he's been a board member of Emma Foundation not constitute conflict of interest. That his conflict of interest arose when Emma Foundation entered into a partnership with the defendant, which interest the claimant declared to Johnson Ekele. Claimant's counsel on the issue of fair hearing urged the court to hold that the claimant was not given fair hearing before his appointment was terminated, that both the panel of investigation and the review panel did not give him fair hearing before submitting the respective recommendations. Learned counsel for the claimant stated that fair hearing envisages both parties to be given opportunity of presenting their respective cases without let or hindrance. And it also envisages that the court hearing the case should be fair and impartial without showing any degree of bias against any of the parties. Counsel started the cases of Alstom and Saraki and Delop and State. It was argued by the claimant that the defendant's country director, who considered the Gimba-led panel, had already prejudged the matter by pronouncing the guilt of the claimant in Exhibit CW5. It was also argued that DW1, who signed the termination letter of the claimant, a letter appointed to lead the review panel to hear the claimant's appeal, cannot fairly, without bias, hear the claimant's appeal. That both the Gimba-led panel and the review panel were not impartial and urged the court to so hold. On issue number 3, counsel finally submitted that the counterclaim of the defendant was abandoned, and therefore urged the court to dismiss him and find and hold that the claimant has proved his case. Defendant's reply on points of law. Defendant's reply on points of law dated 23rd of January 2020 was filed on 24th January 2020. However, claimant's counsel, in amplifying his final written address, urged the court to discountenance some of the arguments contained in the defendant's reply on points of law, because they are either fresh issues and or misconceived. Court's opinion. My critical look at the pleadings of the parties, the evidence adduced, and the submissions of the respective counsel reveals that the claimant was employed by the defendant in 2005 in a 3-year contract job, where the contract was renewed in 2009. That by virtue of the defendant's policy manual, the claimant was required to declare his conflict of interest in any project undertaken by the defendant. But according to the claimant, the policy did not state the method of declaration on conflict of interest. According to the claimant, when he was seconded to a project called Enhancing Nigeria Revenue, ENR, HIV/AIDS in Benin State, which has its own standard operating procedure, he ceased to be bound by the policy manual of the defendant. The claimant, being a board member of Emma Foundation, which was also a beneficiary of funds under ENR, declares his involvement in Emma Foundation by orally informing his line manager, Johnson Kelly, the state program manager of ENR. As a result of the claimant's declaration, Johnson Kelly deployed him to Zone 6 Central District of Benue State to work there, so as not to get involved in the selection process of benefiting NGOs in Zone A, where Emma Foundation was located. That when Emma Foundation had some internal issues which made it impossible to deliver its mandate, it withdrew from the program, as a result of which the defendant set up a Gimba-led panel to investigate the circumstances surrounding the withdrawal of Emma Foundation from the program. That the panel recommended termination of the claimant's appointment, and when the claimant appealed the decision of the Gimba-led panel, a review panel was constituted, which recommended for the conversion of the termination of suspension to 4 months without pay. Now, it becomes pertinent to me to observe that the key issues that should be addressed in determining the instant case are whether the claimant did declare his interest in Emma Foundation to the defendant in accordance with his contract of employment with the defendant, and whether he was given fair hearing before he was terminated and subsequently suspended for 4 months without pay. In law, once parties of their own free will and volition enter into a written agreement, they should be in law bound to honor and be bound by the terms of their agreement, and therefore the relationship and subsequent disagreements must be resolved in accordance with their agreement, and the court cannot go outside the terms as agreed upon by the parties. It was held in Ahmed and CBN that the parties are bound by the terms of their contract, and the court cannot read into such contract what was not within the contemplation of the parties, except where fraud, duress, or misrepresentation can be established. It is instructive to add that the terms of contract between the parties are clothed with some degree of sanctity, and if any question should arise with regards to the contract, the terms in any document which constitute the contract are arguably the guide to its interpretation. It's not within the purview of the court to write a contract for the parties. See the case of Minhaj Holdings Limited and AMCON. The court, therefore, in considering a contract and in determining whether there has been a breach of that contract, are enjoined to confine themselves to the plain words and meaning derived from the document. See the case of Oyamenda and Abdurrahman. In determining the key issues earlier raised in this judgment, I need to refer to exhibits CW2 and CW3, which are the claimant's contract of employment and defendant's policy manual respectively. Clause 22 of exhibit CW2 states as follows. Now, I quote, outside interest. You may not pursue outside interest, business or otherwise, of any kind, which could be furthered by virtue of your employment with Action Aid Nigeria, or that could be prejudicial to your position with Action Aid Nigeria, unquote. Similarly, Article 4.11 of Exhibit C3 also states as follows. And I quote, conflict of interest. Staff in ANA are required to disclose any potential or real conflict of interest with the organization prior to or after they are recruited. Similarly, and staff with recruitment responsibility, line managers, HROD manager, and interview panel must declare any conflict of interest with potential staff as well as individuals for hire in non-staff category, unquote. It's clear from the above that staff of the defendant, including the claimant in the instance case, are expected not to pursue any interest that should be prejudicial or be in conflict with their employment, and are required to disclose that interest to the defendant. Claimant under cross-examination agreed that he was required to declare any interest to the defendant. Nevertheless, claimant has argued that since exhibit CW3 did not specifically state the method of the declaration, coupled with the fact that it is the standard operating procedure of ENR that will bind him, then his verbal declaration to his line manager, Johnson Ekele, is sufficient to satisfy the requirement of exhibit CW3. I need to observe that from the provisions of exhibits CW2 and CW3 and exhibit DW1A to D, which are 4 samples of registered interest and duty forms, which are shown to have been filled by the defendants, which in DW1 and other staff. The declaration of interest meant to be disclosed according to the tenor of exhibit CW2 and CW3 ought to be in line with the register of interest forms exhibit DW1A to D. DW1 under cross-examination stated that the forms have been in existence since the defendant started, and some people have filled the forms in 2005, but she did not bring the claimant's form because he did not fill and submit same. However, the claimant, on the other hand, denied any knowledge of the forms and postulated the argument that it was recent innovation introduced by the defendant during the pendency of the case. This court, in determining the issue before it, shall consider all the documents, including the conduct of the parties. It is settled that in the interpretation of a contract involving several documents, the documents must be read together. See the case of CBN and Iguilo. Equally, the position of the law remains established that in the interpretation of a document or judgment, the documents or judgment must be read as a whole and not in isolation of others relating to the same issue. See the case of Mbani and Basi. That is to say that all the exhibits tendered by both parties must be read together in arriving at a just conclusion. I find from the above that it should not be in tandem with the import and purport of exhibits CW2 and CW3 with regards to the declaration of interest to suggest that verbal declaration of the claimant's interest verbal declaration of the claimant's interest to the defendant is sufficient. I am of the respective view that the register of interest forms exhibit DW1A to D cannot be said to have been manufactured or designed by the defendant just for the purpose of this case, contrary to the claimant's assertion. I find it difficult to agree with the claimant that the register of interest forms are not relevant. In the light of that, I decline to grant the claimant's relief number 8. This takes me to another important point of whether the claimant, right from the commencement of his employment or as a result of emergence of certain events, needed to disclose his interest to the defendant. Claimant under cross-examination stated that he was employed in 2005, registered Emma Foundation in 2006. That at the time of registering Emma Foundation, he was the chairman, board of trustees, that he was aware of the fact that when he was employed by the defendant, he was required to declare any interest to the defendant. That after his appointment, he declared his interest to the defendant sometimes in 2009, that he was seconded to ENR project by the defendant, but he remained a staff of the defendant. And the defendant policy manual exhibit CW3 is applicable to him, as well as exhibit 4, the standard operating procedure of the project he was seconded to. That once one is seconded to a particular project, then the standard operating procedure of the seconded project supersedes the standard operating procedure of his mother organization. He stated that his secondment did not stop him from obeying the standard operating procedure of the defendant, and that he declared his interest to Mr. Johnson Ekele so as to convey it to his mother organization. Exhibits CW26 to CW27 are incorporation documents of Emma Foundation. The documents show that Emma Foundation was incorporated in 2006, and the claimant of the chairman board of trustees. I find from the incorporation documents the circumstances of this case that Emma Foundation had similar aim/objectives with the defendant, and that the claimant ought to have, right from 2006, when Emma Foundation was incorporated, disclosed his interest in Emma Foundation to the defendant. It's my opinion on this point that without the verbal declaration made to the claimant's line manager in 2009 was sufficient or not, it's of little moment. Since the claimant, right from the outset, was bound to declare his conflict of interest to the defendant. The claimant is bound by his contract of employment and the defendant's policy manual to disclose his interest to the defendant right from the time Emma Foundation was incorporated. I am of the opinion that by the evidence of CW1, that the defendant's policy manual and the standard operating procedure are applicable to him, and that he remained as staff of the defendant even after the secondment, does not mean that he would not be bound by the provisions of this contract of employment and the defendant's policy manual and declaration of interest. Turning to the issue of fair hearing, claimant has contended that he was not given fair hearing by the defendant, that the country director had already prejudged him guilty, while both the Gimba-led panel and the review panel refused to call Johnson Ekele, his line manager, to testify before them in his favor. It was also contended that GW1 refused to avail the claimant the necessary documents he needed to prepare for his appeal. Claimant also impugned the competence of GW1 to lead the review panel, being the one who signed his termination letter. Exhibits CW5, CW6, and CW7 appear to prove contrary to what the claimant would like the court to believe. Firstly, I'm unable to see how the statement of the country director in Exhibit CW5 constitutes a breach of fair hearing. And again, Exhibit CW6 equally contains responses of the claimant with regards to the questions raised in Exhibit CW5, while Exhibit CW7 is the report of the investigative panel, which indicates that claimant and others were given a hearing by the panel. The said exhibits show that the claimant was confronted with the allegations and he made his presentation to the investigative panel. Claimant stated under cross-examination that he was invited by the Gimba-led panel and made presentations, but his main grounds is that he disclosed his conflict of interest to his line manager, who was not called by the defendant to appear before them to confirm the statement of the claimant. Nonetheless, the appeal panel in Exhibit CW10 stated that it contacted Johnson Ekele, who responded as follows. And I quote, with respect to our inquiries, there was no formal documentation of declaration of conflict of interest by Fanen Ade as regards Emma Foundation. However, he confided in me prior to the party process that Emma Foundation was opened by his family in memory of his late father. To ensure that he did not interfere with the outcome of the party exercise, he was sent to Benin South Central District along with Roslyn Ode to Padif, the CSO's partners in that axis, while Meme Audu, Stephanie Dada, Benue Padre team leader, and MC Iron, a staff of Bensaka, were assigned the task of assisting CSOs from Zone A, where Emma Foundation comes from, unquote. It was held in Joseph and First Island Bank Nigerian PLC that an employee was confronted with allegation of misconduct before his employment was terminated, cannot complain about lack of fair hearing. See also the case of Udo and CSC Akwa Ibom State. The law is also that where an employer dismissed or terminated the employment, the appointment of an employer on grounds of misconduct, all that the employer needs to establish to justify his action is to show that the allegation was disclosed to the employee, that he was given a fair hearing. That is to say, the rules of natural justice were not breached, and that the disciplinary panel followed the laid down procedure, if any, and accepted that he committed the act after investigation. See the case of Unicala and ASEAN, University of Calabar and ASEAN, and the case of Udo and CSC Akwa Ibom State. I wish to observe that if the claimant failed to be satisfied with the statement attributed to his line manager, Johnson Ekele, that he confided his interest in him, the claimant should have called the cell line manager to testify in court in his favor, but the claimant did not take that opportunity to call Johnson Ekele. I find from the above that the claimant's relief number B cannot be granted as the statement of the country director in Exhibit 5 does not actually constitute any pronouncement on the guilt of the claimant. Claimant in his relief number D asked the court to declare his termination on grounds of fraud and dishonesty as wrongful, illegal, unconstitutional, null and void. My take on this is that the defendant had already reviewed the termination and converted same to suspension for 4 months without pay by issuing Exhibit CW11 to the claimant. I observed that Exhibit CW11 stated that claimant's termination was converted to suspension only on the ground of conflict of interest. I find that Exhibit CW11 do not allege any fraud or dishonesty against the claimant, which I also endorse. It even stated that the claimant would be expected to resume duty by 3rd of October 2011 after the 4-month suspension. The claimant alleged in his relief number C that the defendant was not justified in still finding him guilty of dishonesty and fraud after finding in his appeal panel that he declared his interest to his line manager. However, contrary to this contention, the defendant did not in his suspension letter, Exhibit 11, allude or hint at any fraud or dishonesty. On the whole, I'm unable to find any basis for the grant of the claimant's relief. To me, he has not been able to prove his case. The case fails and is hereby dismissed. His verbal declaration of interest was not in line with contract of employment, and I find that he was given a hearing by the defendant, but only to the extent of the issue of conflict of interest as suggested by suspension letter, Exhibit CW11. On the defendant's counterclaim, I find that there is no sufficient evidence to prove the counterclaim. It also fails and is accordingly dismissed.
Well, we appreciate the Honorable Court for that sound judgment.
Mr. Agassi, okay.
Yes. We appreciate the judgment of the court.
Thank you.
Yes.
Mr. Agassi?
Yes, my lord.
The defendant reviewed the termination letter and converted him to suspension.
As the court listens.
4 months without pay. So was there wasn't anything fraud or dishonesty in the suspension letter. Why do you have to worry yourself?
As the court listens.
Yes.
As the court listens.
Okay. And I
want to thank you.
And I have also endorsed that one.
As the court listens.
Yes.
And I also want to thank you for the well-considered judgment.
Thank you, Sokwa.
Thank you for your indulgence throughout the trial.
Thank you.
I'm most obliged.
I also wish to thank you for your patience. The time that the matter took before we deliver the judgment, you know, so I appreciate your efforts and patience.
I wish my Lord the very best.
The Honorable Court.
Thank you, Mr. Agassi and Sokwa. Thank you so much.
Thank you
I
very
wish
much.
you a very good evening.
You too, my Lord.
Yes. And I wish you a very nice weekend.
Thank you.
Thank you very much.
Yes. See you next time.
As the court pleases.
Thank you.
Thank you. Lord.
Hello? I'm going to send both the soft copies and the hard copies will be sent next week, next week.
Okay, my Lord.
Yes, we'll get the soft copies, via your, and various emails.
As the court pleases.
So you are going to get the soft copies first because we are going to send the hard copies through courier. So before the hard copies
As a copy.
reach you, you'll get the soft copies next week, God willing. Yes.
As a copy.
Okay, thank you so much. I wish you a very good evening and a happy weekend.
Thank you very much, my Lord.
Thank you very much, sir.